first matter to come before the court this morning is State of Ohio versus Rayshawn Powell. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve that time, if you let me know when you get started, I'm keeping the clock and can keep you apprised of the passage of time. We've read the briefs and are ready to proceed when you are.
I assume I go up here as a...
Yes,
okay.
please.
The first time I've been out here is may it please the court, my name is Russ Mansing. I'm the attorney for Rayshawn Powell. I'd like to reserve 3 minutes of my time for rebuttal. If the judge had made these comments in a jury trial, you'd be first out of hand. I don't think there's any question about that. If the juror had been heard to make these comments and it had been reported to the judge and to the parties, I think that juror would have been excused for cause. I don't think there's any question about that. The only issue here is whether the judge is making those comments while maintaining that he's keeping an open mind about the case is sufficient to require reversal.
Well, let me ask you, since we're just jumping right in with the comments. Obviously, in looking at the comments, you know, they were inappropriate. But the comments were all pertaining, were they not, to the mom, who is not the defendant here.
Well, no, they were pertaining to the mom, but I think they evinced an indication of a predisposition to finding guilt. I mean, he talks not only about why you left your children with this person who was just released from the penitentiary. He calls for the mother to be sterilized, to be shot if she has any more children, and to be, you know, as I put in the brief, his concept of judicial restraint is to refrain from dropping her out of a 7th floor window. And I don't think in that context, I mean, yes, he's criticizing the mother, but what is he criticizing the mother for? Leaving her children with this man just released from the penitentiary, and I think that that reflects an indication on his part that, yes, what did you expect to happen to your children if you left them with this man?
Just saying, basically, you're not mom of the year, what are you thinking? Whether anything happened or not, you created a substantial risk by leaving your children with somebody you hardly knew that just got released from prison.
Well, I think you could interpret it that way, but I think that these remarks in the context of this case, if you look at it from the point of view of the defendant, after these remarks, you're saying this man is going to be judging you. This man is going to be determining your guilt. And after those remarks and the ferocity of those remarks, I don't think that there is much question in the defendant's mind, hey, I'm not going to get a fair shake here. And I think that's one of the problems here. When we talk about appeals, we're basically looking at two questions. First of all, was the result accurate? And second of all, was the procedure fair? And whether the result is accurate or not, if the procedure is that far out of bounds, we're going to reverse, because due process is a requirement under the Constitution, and part of that due process requirement is that the defendant receive a fair trial from an unbiased and impartial judge. And I think these remarks, in the context of this case, indicated a predisposition toward finding guilt on his part. If he just said, well, you know, that's kind of strange that you leave your children alone. But like I said, he went way, way, way overboard. To say that these remarks were inappropriate, I think, understates the case substantially. They were wildly inappropriate. And I don't think, looking at these remarks, we can have confidence that this judge engaged in a fair and impartial determination of guilt. And that's the whole problem with this case. If the procedure isn't fair, then we have no confidence in the result. And these remarks in this context indicate a predisposition toward finding guilt, and I don't think this man had a fair trial as a result of it. Now, the second problem that we run into is, of course, with regard to the prior accusations of false accusations of rape. And YM admitted that she'd made some statements regarding rape, and the judge cut off any inquiry onto that. Now, this was a bench trial. If this had come up in the middle of a jury trial, that's a different problem, because under the rules...
May I ask you a question about it? It's minor. From what I'm reading from your brief, it says, has there ever been a time when you falsely accused somebody of doing this type of thing to you? She said no.
She said no at that point, yeah, and if I can just,
The next one said if you're going to falsely accuse them of anything, that's when she said yes, so.
Yeah.
Anything of this sort, I would presume had to do with rape.
yes.
She flat out said no.
Well, she said no, but and again, let me just. I think that in the context of a judge trial, okay, like I said, if this was a jury trial, then I think it was incumbent upon the defense to bring this to the court's attention prior to trial, ask for a Rule 104 hearing to ferret, Boggs hearing under Rule 104 to determine the admissibility of that. But this is a judge trial, and I think the procedures could have been more informal in this situation, that the judge could have conducted a fuller hearing. He shut off the defendant immediately upon the answer. And I think that he had, my understanding is that he had some additional evidence regarding that, and considering that this case boiled down to the credibility of the victim. I mean, other than you don't have any no medical records were even introduced in this case. The detective didn't testify in this case. The only thing you had besides the girl's testimony was the polygraph examination, and despite the stipulation, I mean, there's a reason that we don't credit that a whole lot. So I think overall, I think that in this situation, the defendant, first of all, should have been allowed to explore that in a hearing to determine and not be cut off just because she says no. Because I think that, again, there's, beyond the rape shield statute, there's some constitutional ramifications of the rape shield statute and the right to present a defense. And I think in this situation, the defense should have been allowed to explore that more.
Well, what did he ask to do though?
What's that?
What did the defense counsel, what did he request once he was, did he request a hearing?
No, he didn't. He didn't.
So basically you're arguing plain error, but not
Pretty
really,
much.
but it's really not plain error in the brief either, I don't think.
Yeah. So I think that this is a situation where basically, as I said, this man didn't get what we would call a fair trial. I think the remarks by the judge in this case cast doubt upon the verdict. When you have the judge voicing that kind of opinion in this kind of trial, I don't think that anybody looking at those remarks would wonder what the outcome of the trial would be.
Let me ask you some questions. Would any objective parent sitting in a courtroom, listening to this testimony, hearing that this woman left her 4 children, as well as Ms. Perez has 7 children living in the house as well, right? So she has her 4 children all under the age of 14, and I presume Ms. Perez might have had children in the house as well, with a person she doesn't know. Wouldn't any parent in their right mind wonder?
Well, I think they would.
Didn't he him just enunciating what everybody else is thinking, does that make it unbiased?
Well,
Does it make it
I think the problem is, first of all, what people in the courtroom are thinking is one matter, what the judge is thinking is another, and what the judge is saying is a third, and that's the problem here. This isn't simply the judge making an offhand comment about it. It's not just the judge thinking, well, geez, what are you doing leaving your kids alone with anybody, okay? This is a judge voicing opinions to the extent, let me put it this way, I don't think anybody sitting in the courtroom who heard those judges' remarks would have any doubt what the verdict was going to be. And that's the whole problem here.
I gather from the brief, and correct me if I'm wrong, that comments were made in the courtroom, but outside the presence of the mother.
Outside the presence, yeah, she had left.
The defendant was present.
Yeah, the defendant was present. This was not made to the mother. This was, it's not clear in the record, but from reading the context of the remarks, because, he talks about her as if she is not present. He asks other people, well, you're making sure that, the kids are going to be taken away from her, whatever, that she's not going to have children. So I think that that's correct.
And how far along in the proceedings was it?
That was I believe the mother testified first.
Right.
She was the first
Mother
witness.
testified.
Okay, so this came out right at the beginning.
She was in the courtroom, it was the child that left the room. The mom was still in the room.
Okay.
It was the child apparently that left the room.
Well,
According to the brief, it says, court expounded at this conclusion of YM's testimony, wished to address the group in the back with YM out of the room. After she left, the court stated the following in the letter. So that's when he...
okay.
So the child wasn't present, but
Okay.
apparently...
I would assume that the child wouldn't have present. I thought
Right,
that
right.
the comments came after the mother's testimony. If there are no further questions, I'll reserve my time for rebuttal. Thank you.
May it please the court, my name is Natasha Ferrari and I represent the state of Ohio on this matter. Just with regard to the first assignment of error, and I think Judge Carr stated it correctly, is that these comments were all made with regard to the mother and her parenting skills, or what the court thought was lack thereof, with regard to the situations that she left her child in. The judge wasn't making comments with regard to the parties or any sort of ill will or feeling or hostility toward Mr. Powell in this matter, or with regard to his guilt or innocence at that point. He stated that he still had an open mind, was open to any defense that would be presented on Mr. Powell's behalf. So these comments.
Well, wait, let me back up a little bit. We don't know for sure what he was meaning. So one argument could be made, like I said, to appellant's counsel, that he's just remarking on her lack of parenting skills, because that was just an extreme risk to have anybody watching your children, let alone somebody that you don't know, let alone somebody who's just out of prison. However, we're not sure where the judge is coming from. I mean, it also could mean like, my gosh, he just raped your child, what were you thinking? So that's the other interpretation that could be taken from it. But when you say, he said he would keep his mind open to any defense, that's a little problematic, isn't it? Because he doesn't have to present any defense, he doesn't have to do anything, the state has to prove the case.
And that's correct. It is the state's burden with regard to any sort of guilt or evidence presented with regard to that matter. But in just looking at his statements throughout, it appeared that it was more of a, he's not making these comments and therefore reflecting directly upon what he was going to decide with regard to his guilt or innocence, and that he was open-minded to anything with regard to if, in fact, Mr. Powell was going to present any sort of defense, and Mr. Powell did, in fact, testify in this matter. But these statements really did seem to point, and the judge did question the mother when she was on the in the witness stand with regard to why were you leaving your children alone with somebody. So that did seem to be just in the context. Obviously, I cannot read the judge's mind, but in reading the transcripts, my interpretation of what he was stating at that point. And then with regard to the second assignment of error, it is correct that a party can question a witness with regard to truthfulness and veracity. However, in rape cases, there is that special statute, the rape shield law, that prevents any sort of, any question with regard to a victim's prior sexual activity. And this Ohio Supreme Court in the State versus Boggs did indicate that a defendant can question a victim with regard to whether or not she had or had not made any sort of prior false rape accusations, but it was only upon the victim actually stating that yes, she had or he had made a prior false accusation, then the judge had to go into an in-camera hearing to determine whether or not the defendant could make any sort of further questioning with regard to those allegations. Here, the defendant was able to question the victim, ask whether or not she had in fact made prior rape allegations that were deemed false, and she stated that she had not. And it's the state's contention that at that point, Mr. Powell was left with the answer that he received on cross-examination pursuant to State versus Gardner. that the trial court was correct in not allowing him to further question her with regard to that matter, because she had in fact stated that she had not made those prior false allegations, and that any further testimony with regard to that would be prohibited under the rape shield law. Therefore, just based upon the briefs as well as my arguments here today, the state would request that this honorable court uphold the finding of the court and overrule both of Mr. Powell's assignments of error in this matter. If there are no further questions, thank you, Your Honors.
A couple of points of clarification. First of all, the statements by the judge did take place after YM's testimony, but Ms. Morales had testified earlier. I don't believe she was still in the courtroom. She had testified earlier and had been excused. The second point I think is more critical. Judge Schaefer, you'd asked me about, I believe it was Judge Schaefer, asked me about what the witness had answered. And yes, the answer to the question whether you falsely accuse somebody of doing this type of thing to you was no. But then the next question was there ever a time when family members didn't want to take you in because they thought you were going to falsely accuse them of anything? And the answer to that is yes. Was there a time when that happened? Yes, I had, and that's when the prosecutor objected and the judge shut off everything. And the judge's explanation for that was, if you're asking her if someone had accused her of making a false complaint of sexual abuse, I probably should have sustained the objection to the question before that unless you can determine some relevance to the accusation. Well, the relevance is that she has falsely accused somebody. And I think the state goes too far in contending that the witness's answer is determinative there. I think if there is evidence of a false accusation, even if the witness doesn't admit it, if, for example, there had been a police report filed by the witness claiming that somebody had raped her and the police had determined that it was a false accusation, I think that evidence could be presented at trial. I don't think that you have a situation where the witness can determine whether you go into that simply by saying, no, I never made the false accusation. I think that obviously the judge misunderstood the situation here. He determined that his determination was based upon that there wasn't any relevance to the accusation. A false accusation of rape is always relevant. And here, given the witness's answer...
Let me ask you, aren't you presuming that it's a false accusation of rape? Because it doesn't say that.
Well, no.
Somebody, she could be, hypothetically, she could be a truant, and I don't want to take her in the house because you never go to school and I'm not going to chase you down. I mean,
well,
there's a lot of different reasons why a family member won't take a kid in, right? It doesn't always have to be that because you're falsely accused of rape.
Well, two things. First of all, I think in the context of taking them in to report a rape, I think that when you have, and the statement is, didn't want to take you in because they thought you were going to falsely accuse them of anything, I think that there is a connotation of rape in that situation. And more importantly, I think that's a subject that needs to be explored. I think that the defense presented sufficient information regarding the possibility of a false accusation of rape. And again, this is a credibility determination here. And I think in those circumstances, the judge should have allowed an exploration of that point. And I think shutting the defense down totally was improper. Any questions? No? Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on the House Supreme Court website. Thank you so much.
Thank you.